name is Caio Castellano. I will be hosting you in this section. I'm also an author of a presentation that will be done in this section. We will have 4 works presented here. The works are public management compliance, access to information versus data protection. The second one, presented by me, will be unclogging courts by targeting litigant incentives, the case of the Brazilian labor justice reform. The third work will be when autonomy is necessary for performance, a study on Brazilian public defenders' offices. And the last one, last but not least, it will be theory and practice, women victims of sexual violence in criminal justice systems. So I would like to welcome everybody, including the authors of the presentations. Each one will be done in 15 minutes. And after all presentations, we will have a short debate. So I invite all people watching us to send questions using the chat, and then I will read the questions for the author of the paper of the question. Okay, so let's start our works today. The first work to be presented, public management compliance, access to information versus data protection. I think that the author that will present it will be Luisa. So we have Luisa here.
Caio, deixa eu fazer só uma perguntinha. É em inglês mesmo? Porque acabou que a gente fez a preparação em português da apresentação.
I will explain. Então, pode fazer em português, que aí quando for em inglês dos outros, eu mudo para inglês, mas eu vou explicar para as outras nossas. Tem umas autoras nessa sessão que são em inglês, eu vou explicar para elas.
Ok. Entendi.
Okay. We have 4 presentations today. The presentations were submitted in English, but some authors decided to present it in Portuguese, considering that the authors and most of the audience is in Portuguese. However, there is no problem for the last one that are Spanish authors that will present in English. I will present in English also, but no problem for now for Luisa presenting his work in Portuguese. So let's go, Luisa.
Ok. Estou só compartilhando a tela, aí se vocês puderem dar um ok.
Presentation, okay.
So I'm going to do this little introduction in English. I'm sorry, but we prepared the presentation in Portuguese. But I am Luisa, and this article was made with my colleague in Schema Business School, Sabrina, with the orientation of our professors Paulo and Max. So today we are going to discuss a little bit about public management compliance and focus on the conflict between the access to information and data protection. Agora eu vou seguir um pouquinho em português, mas então, para contextualizar, né? No primeiro artigo da Constituição Brasileira de 1988, a gente tem expresso que o Brasil ele se constitui como um Estado democrático de direito. Então, as leis são criadas para o povo e pelo povo, tendo em vista a dignidade da pessoa humana. Então, o que acontece? Para garantir a existência dessa democracia, a gente deve garantir a característica do governo do poder visível, no qual o público é a regra e o segredo é a exceção. Então, somente assim que a gente vai conseguir ter consciência das ações do governo e ampliar a participação democrática. E isso ele fica muito expresso para a gente no artigo 37 da nossa Constituição, que fala que as formas de participação do usuário na administração pública direta e indireta se farão por meio do acesso dos usuários a registros administrativos e informações sobre atos do governo. Então, né, muitas vezes, esse direito de acesso à informação, ele entra em conflito com o direito à privacidade. Então, o que a gente quer discutir aqui hoje é exatamente isso. Como a jurisprudência entende que nenhum direito fundamental é absoluto, nós queremos discutir como que se dá esse conflito entre o direito à privacidade, o direito à informação pública, frente a um caso concreto que nós trouxemos. Então, um pouquinho sobre o estudo de caso. Esse tema, ele originou a partir de um relatório técnico que foi publicado no evento do ano passado, no Najus 2020. E esse relatório técnico, ele visava apresentar uma ferramenta que foi criada, uma ferramenta de Excel criada para as secretarias do Tribunal de Justiça de Minas Gerais é o estado aqui do Brasil. E essa ferramenta, ela auxiliaria no processo de análise da performance dos funcionários através dos dados extraídos do SIJUD. O SIJUD é um sistema aqui do Brasil, um site, chama Sistema de Informações Estratégicas do Judiciário, e nele a gente consegue coletar diversas informações sobre o dia a dia e sobre as atividades desempenhadas pelos servidores públicos. Então, para ficar um pouco mais claro, eu vou explicar um passo a passo de como que essa ferramenta funciona. Essa ferramenta ela foi criada pela coautora, que é a Sabrina, e foi desenvolvida essa análise em cima dela. Então, o primeiro passo aqui nessa primeira imagem é a extração dos dados. Então, para a extração dos dados, basta entrar no SIJUD, que é o Sistema de Informações Estratégicas do Judiciário. Então, e aí, nesse SIJUD, a gente consegue extrair essa planilha que está na segunda imagem. E o que é o SIJUD? No próprio site do Tribunal de Justiça de Minas Gerais, ele mostra que o SIJUD ele tem como objetivo exatamente facilitar e disponibilizar o acesso à informação para a gestão. Então, esse é o objetivo do SIJUD. E nosso objetivo aí, com essa ferramenta, foi exatamente melhorar esse objetivo e conseguir ajudar as secretarias a desempenhar isso de forma melhor. Então, a partir da planilha, que está na segunda imagem, essa planilha é copiada e colada na planilha de Excel, que está na terceira imagem, e por meio de uma automatização total, basta clicar em um botão, já é criado vários gráficos da análise de performance e de desempenho dos funcionários. Essa análise é baseada em alguns índices criados de acordo com as demandas dessa secretaria. Então, já na quarta imagem, que é o Power BI, a gente consegue atualizar automaticamente os dados do sistema. E todas as visualizações também são automatizadas. Então, você publica todos os relatórios do mês, todas as análises que você quer ver, com um link editável, e com um link qualquer pessoa pode ter acesso e visualizar. Esse link não é editável, mas qualquer pessoa pode ter acesso e visualizar. Então, apenas com um link. Então, eu posso ter acesso, o Caio pode ter acesso. E aí, a gente vê aqui uma evolução. No novo formato, a proposta é facilitar ao servidor o download dos dados do portal do SIJUD e colar para o acesso dentro de uma planilha do Excel. Então, esse objetivo aí principal foi facilitar nessa evolução nossa. O Power BI, então, ele é conectado a essa planilha. Então, o que acontece é que os dados são carregados instantaneamente. Um dos principais diferenciais desse uso é a fácil visualização do compartilhamento da informação. Exatamente porque qualquer pessoa pode ter acesso ao gráfico e todas as análises. E anteriormente, o servidor tinha que baixar uma planilha individualmente e depois colocar individualmente nessa planilha de Excel. E atualmente é tudo já bem mais automatizado. Além disso, a gente tem também uma restrição mais técnica, que os servidores aqui de Minas Gerais, eles não têm acesso ao Excel. Então, eles não conseguiam visualizar o Excel durante o momento do trabalho, no computador do trabalho. Agora, eles conseguem ter acesso a essa análise exatamente por causa desse link na internet. Então, a gente tem aí, né, essas duas interfaces, além de todas essas melhoras do processamento e da facilidade de visualização, a gente tem uma visualização muito mais amigável do que na ferramenta Excel que está nessa imagem abaixo. E aí a gente entra um pouco na problemática, né? Para entender a aplicação dessa ferramenta frente a esse conflito dos direitos fundamentais, foi feita uma pesquisa doutrinária, jurisprudencial, e dos princípios e dispositivos legais. Então, a gente baseou no princípio da proporcionalidade, que ele se utiliza das 3 etapas para avaliar uma questão. Então, a adequação, necessidade e a proporcionalidade no sentido estrito. Quando a gente fala na adequação, é exatamente conseguir alcançar o fim pretendido. A necessidade é utilizar os meios menos gravosos para atingir esse fim. E a proporcionalidade é o balanceamento entre o direito fundamental, que vai ser mais relevante nessa situação, e o direito fundamental que vai sofrer certa restrição. Então, é basicamente uma análise custo-benefício, pensando qual direito fundamental trará mais benefícios para a comunidade, no geral. Então, aí, né, são só alguns trechos de duas decisões que nós conseguimos ver como que isso fica bem claro. Aí a gente consegue ver na primeira decisão, foi sobre a publicidade dos dados da remuneração dos funcionários públicos. E a gente vê que realmente o que foi decidido é que não há uma colisão de direitos, porque os dados são de natureza estatal, então não viola a intimidade, não viola a vida privada. E no segundo, uma fala do ministro Marco Aurélio, ele fala que a gente não pode pretender que o funcionário público tenha a mesma privacidade que o cidadão comum. O servidor público, eles são a vitrine, né, que ele coloca nessa decisão, que é muito interessante. Então, um livro aberto entre o interesse coletivo, o interesse público e o interesse privado, prevalece o interesse público, prevalece o interesse coletivo. Aí a gente trouxe um pouquinho mais, até sobre o SIJUD, para mostrar o que é o objetivo do SIJUD. Então, a gente consegue ver que o objetivo do SIJUD é armazenar os dados. E armazenar os dados exatamente para facilitar a medição da performance e a gestão. E esse foi o nosso objetivo com a ferramenta e nessa análise. Essa ferramenta em questão, ela colabora para o cumprimento de vários dispositivos também da Lei de Acesso à Informação. A Lei de Acesso à Informação, que é a Lei 12.527, ela tem o objetivo regulamentar o direito constitucional do acesso à informação, fortalecendo o desenvolvimento da democracia participativa. Então, a gente consegue ver, destacamos aí o artigo 5º e o artigo 8º da Lei de Acesso à Informação, a gente consegue ver como que a ferramenta colabora para esse lei. Então, no artigo 5º, a gente consegue ver que as informações devem ser transmitidas de forma ágil, transparente, clara e objetiva. E além do fácil acesso, que é destacado no artigo 8º. Então, aqui a gente resolveu trazer também algumas tendências, né, para mostrar que como essa publicidade da administração, aliada às tecnologias, é realmente uma preocupação muito grande do governo. Então, nós temos o projeto de lei número 7.843, que ele realmente pensa, né, na integração de sistemas e acessos à base de dados da administração pública. E ele traz vários conceitos muito interessantes, como governo de plataforma, e além de pensar em toda essa infraestrutura tecnológica. Então, como a nossa ferramenta, ela também pensa nessa preocupação de desenvolver os mecanismos para aproveitamento de dados, na maioria da eficiência de secretarias do Poder Judiciário, que é o objetivo da plataforma, ela vai muito de acordo com esse projeto de lei, que pensa na integração dos sistemas, a integração das informações, dos dados, governo em plataforma e infraestrutura tecnológica. Como uma outra tendência, eu não sei se vocês conhecem o Open Government Partnership, é uma iniciativa que tem o Brasil como país fundador. Hoje conta com 78 países e busca o desenvolvimento de planos de ação para promover a transparência e melhorar a participação pública. O Open Government Partnership ele tem 4 princípios principais que regem. E a gente vai mostrar como que esses princípios estão alinhados com a plataforma. O primeiro princípio é a prestação de contas. E a plataforma ela permite a verificabilidade do andamento do trabalho dos servidores públicos. O segundo é a participação civil. E a plataforma ela aumenta o engajamento, porque você consegue ter uma proximidade maior com as questões administrativas do setor público. A terceira é a transparência. E as informações são divulgadas de forma clara e objetiva. E a última é exatamente a tecnologia. E a plataforma ela utiliza de tecnologias para o cumprimento de todos esses outros princípios. Então, como conclusão do nosso trabalho, a gente consegue ver que a gente tem uma ponderação do direito à privacidade e o direito de acesso à informação pública. Por meio das pesquisas feitas, nesse caso concreto, nós trouxemos da plataforma desenvolvida, tem uma tendência de priorização do acesso à informação, exatamente por se tratar de informações relevantes para a população acompanhar o recurso, onde estão sendo alocados os recursos do Estado e ainda o trabalho dos servidores. Então, a ferramenta, além de acordo com os princípios legais, ela ainda colabora mais para a efetivação, exatamente por proporcionar a visualização de forma mais clara, acessível para os gestores, e eles conseguirem exatamente fazer a gestão, né, dos recursos e das pessoas de forma mais efetiva. Como limitações do estudo, a gente gostaria de apresentar aqui que foi desenvolvido em uma única secretaria do Tribunal de Justiça de Minas Gerais, apesar de já estar sendo aplicado nessa secretaria, isso se torna uma limitação. A replicação por departamentos, do jeito que o sistema está, é difícil, porque ele foi pensado para essa secretaria. E, além disso, né, esse sistema ele não considera as outras atividades desempenhadas por servidores. Ele considera apenas essas atividades que são registradas no sistema SIJUD. Então, acaba que tem uma interpretação da performance com resultado parcial, que deve ser analisada exatamente pelos gestores da área, que conseguem interpretar e utilizar essas informações. Igual foi demandado para nós a construção dessa plataforma, exatamente por uma demanda dos próprios gestores da secretaria e dos próprios funcionários da secretaria. Então, eu queria agradecer pela oportunidade. Qualquer dúvida pode entrar em contato conosco. E muito obrigada. Acho que está mutado.
Hello, thank you to Luisa. A good presentation. I'm facing exactly this problem in my organization in Brazil. That's Advocacia Geral da União. We are struggling between exposing data and thinking about data protection in the personal level. But the question is, it's not because some data is personal or connected to someone that it's not public. It's also public, and so the public also has right to access that because of the principle of the transparency, yeah, the publicity. So okay, let's go to the second work. The second work is a work done by me and two other authors, Eduardo Watanabe, that's here with us today, and also Peter Grazich, that is an American professor, an economist from the Washington Lee University. I will share my screen with you today, so it will be easier for you to understand my presentation. So let's go. This is the name of the work, Unclogging Courts by Targeting Litigant Incentives, the case of the Brazilian labor justice reform. What was the problem that we would like to address with this research? There is a problem in Brazil and also in other countries that is the many courts have many pending cases to decide. And we know that overburdened courts hinder economic and social progress. So when you have a court delay, we have countries with a slower development, economic development. And so usually congressmen try to reform the courts to promote economic development. But successful court reforms are rare. There is a natural challenge to promote efficiency in courts, and usually the solution found by reformers is boosting judicial resources. For example, hiring more judges, hiring more judicial assistants, or increasing the court budget. But there is two problems with this kind of solution. The first one is that, for example, in Brazil, there is a budget ceiling and we cannot expand public expenses anymore. A second point is that Brazilian courts cost very much. The Brazilian courts correspond to 1.5 points of our GDP. They are the most expensive courts in the world. And another point is that usually when you boost judicial resources, when you, for example, hire more judges, the pressure over the incumbent judges decrease, the pressure over the judges that are already there in the court decrease, because now they have more judges to divide the work, and they decrease judicial productivity. They decrease their production. So we don't know if this traditional reform will make some progress. And a second type of traditional reform is adapting procedure, trying to simplify the rules of procedure in the country. In Brazil, we changed our civil procedure code very recently, in 5 years ago, and before that, we changed many other Brazilian rules about civil procedure. But usually, this kind of reform, boosting judicial resources and adapting procedures, does not have success. Congressmen try to state this reform, to impose this reform, but unfortunately, they have not success usually. And what was the case of Brazilian labor court reform? This reform tried to reduce court demand, addressing litigation costs. Of course, every litigation has a kind of cost. We have the cost of the court fees, and also the cost of the attorney, the lawyer. You have attorney's fees. What was the pre-existing rule for litigation costs in labor courts? The rule was each pays their own costs. There was the American rule. So if I am an employee and I would like to bring a case to the court, I will have to pay my own costs. But if I lose the case, I don't have to pay anything to the other side. I just have to pay my own cost. Usually, there is no court fees for people that is poor, hyposufficient, as we say in Brazil. And usually, lawyers receive money from the employees just when they win the case. So usually, employees don't have costs if they lose a case. But now, the new rule, the rule after the reform, the new rule is the loser pays all. That we call that this is the English rule. So what it means? It means that if you lose the case, you will have to pay your costs and also the costs of the other side. You have to pay, for example, the attorney's fees, the cost of the lawyer of the other side, you have to pay to the other side. This increases the risk of litigation, because now you know that if you start a frivolous litigation and you lose the case, you will have to pay the cost to the other side. And what was the perception of the Brazilian lawmakers? The perception was that there was too much frivolous litigation in labor courts, especially exaggerated labor claims about extra hours. People claim, usually to claim that they make a lot of extra hours in a company, and there is an incentive for that, because if they 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 don't achieve this right, they don't have to pay anything to the company. The company must prove that he does not did this amount of extra hours. So what was the solution here? The expectation was, okay, a reduction in the number of new labor filings. Why? Because now the risk is higher. If the employee loses the case, he needs to pay something to the other side to reimburse the cost of the business attorneys. And there is expectation to decrease the existing backlogs and delays, with less cases being filed, with less cases being brought to court. We would have a decrease in backlogs and delays. This is the expectation. But there is a risk also, because when you reduce court demand, perhaps the judges will feel less pressure over them, and they would reduce judicial productivity. They will reduce the number of decisions as well. And so if you have a lower court demand, but if judges start to decide a lower number of cases, start to resolve a lower number of cases, will have no impact on court backlog. And we would like to study, to investigate this phenomenon, to check if there is impact or not. So this is exactly what I described right now. Reducing pressure over judges usually decreases judicial productivity. So the risk of no reform effect. And what was the research question, or the research questions? What was the impact of the reform on court demand? There is some impact on court demand, changing this rule of litigation costs. If the reform reduced court demand, how large was the effect? Did the reform exert any effect on court backlogs and delays? And are the effects also detectable in the context of enforcement? Because we have the adjudication, known in Brazil as fase de conhecimento, and the enforcement phase, fase de execução. So we have this effect in adjudication and also in enforcement, or not? Our data. We have two kinds of sources: the Labor Council of Justice, where we achieved data from labor courts, referred to labor courts, and the Federal Council of Justice, where you achieve data related to the federal courts. So we have data from all labor courts and all federal courts from 2015 to 2019. The method is the differences in differences. So, okay, we are trying to see if the reform decreased the number of new cases brought to courts. But how we do that? We compare labor courts to federal courts. So we have this long line, dashed line here. They are the labor courts. We see a decrease here from 2017 to 2018. And we see also that the federal courts were not affected, of course, by the reform in labor courts, and they maintain the level of the cases, the number of cases being filled. So when this method is basically a comparison between one phenomena, in this case, the number of cases filed in labor courts with a control group. In this case, the federal courts, like we do when we test a new medicine. For example, we have the group that takes the real pill, and the other group, the control group, that takes a placebo, for example. So here, the labor courts are the real group, and the federal courts are the control group. This is the spirit of the differences in differences methodology. Results using the average effects estimation. In adjudication, that is, fase de conhecimento, what were the effects? The number of new filings, the number of cases brought to court reduced 38% after the reform. The number of resolved cases also decreased. The number of resolved cases decreased 32%. So we see that there is also a reduction. This is normal. This was expected because now the pressure over judges are lower, but the number of cases, the number of resolved cases decreased less than the number of new filings. So the clearance rate increased from 95% to 103%. I will explain that. What is the clearance rate? The clearance rate is a very simple statistic, a very simple index. It shows, it compares the number of new filings in 1 year and the number of resolved cases in the same year. If you achieve 100% in your clearance rate, it means that you decided all the cases, a number of cases that it's equal to the number of new filings in that year. If you resolve just 95%, it means that 5% of cases filed in that year were not decided in that year. And if you have more than 100%, in this case 103%, it means that you are deciding more cases, a number of cases that's higher than the number of cases filed in that year. So after the reform, labor courts started to decide 103% of cases, achieved 103% of clearance rate. It means that it started to decide more cases than the number of new filings. In other words, it started to decide cases in the backlog and reduce the backlog because they were able to decide not just the number of cases that are being filled, but also some cases that come from somewhere. In this case, of course, the case backlog in the courts. So the number of cases was reduced, of pending cases was reduced in 45%, and disposition time, the estimated disposition time was reduced in 18%. That means that they started to be 39 days shorter than the level before the reform. And we have also results and interesting results in the enforcement phase. What's the enforcement phase? It's when you finish a case, you ask the other side to pay to you the amount that the judge decided, but sometimes the other side does not pay anything, and you need to start enforcement procedures. In Brazil, there is a specific phase to this kind of initiative. We call that an enforcement phase. And we see that right after the reform was in 2017. And in the case of adjudication cases, in the new cases that are brought to court, in 2018, the number of cases decreased right after the reform. Yeah, in the year right after the reform, 2018, the number of cases filed decreased. But in the case of the enforcement, they do not decrease in 2018. They decreased in 2019. But why? because you take some time to enforce your cases. So those cases filed here in 2018 with a lower volume, they were processed by courts, and they were eventually enforced, to be enforced just 1 year after the start of the case, that is the next year, 2019. So we have an immediate effect in the number of new cases brought to courts, in the number of education cases, right after the reform in this phase, in this education phase. In enforcement, we also have a decrease in the number of cases filed, but just 1 year after the reform. So we have this gap in time to detect the effect of the reform, but we can conclude that the reform also affected the number of new cases enforced and bring to be enforced in the courts. So the conclusion: changes in litigation costs, in this case, from the American rule to the English rule. So now when you raise the risks of litigation, and someone, the plaintiff, the people, in this case, the employees that is bringing cases to court, they will have more risks to file a case. And now we have scientific evidence, statistical evidence that this kind of change may drastically reduce court demand. It also markedly decreased the stock of education cases. We saw that the pending cases decreased 45%. They shortened disposition times in adjudication. So people that really have real cases are faced now faster labor court, and caused a drop in new enforcement filings. Of course, if you have less new cases being filed, being brought to court, in some time we have less new enforcements being filled. So we can say that the reform, the congressional reform, the reform done by lawmakers, made an effective have had an effective consequence to the system. But this week, exactly this week, 4 days ago, the Supreme Court of Brazil, the Brazilian Supreme Court, declared as unconstitutional exactly those articles promoting this change in litigation costs. Under the point of view of court efficiency, this was not a good decision, but the fact is that now, perhaps in 1 year or in 2 years, we will have another research opportunity to investigate what was the impact of this Supreme Court decision on labor court litigation. Labor court litigation will increase now that the reform was declared unconstitutional or not. So this is a question for the next research. I expect to conduct this research and present here in Enajus in future years as well. So this was my presentation, the second presentation, and now we can go to the third one, remembering that the debate will be done after the presentations, and we have yet other 2 here. Now, I will stop to share. Oops, here. Stop sharing. Okay, very good. Now we are going to the third work of the day. The third work is When Autonomy is Necessary for Performance, a study on Brazilian public defenders' offices. This study was done by Bernardo Oliveira Buta. We have Bernardo here. Bernardo is author of many articles and works related to the public defenders' offices in recent years. I'm sure that this one is also an interesting one, and we will hear Bernardo now. So Bernardo, you have the word.
Thank you so much for the introduction, Caio. You are very kind. Bom dia aos colegas falantes de português, brasileiros e portugueses. Buen día a los colegas que están en España también. Un saludo a todos. Y as Luisa I always thought it was going to be in Portuguese, so I was here early in the morning, the Monday, translating my canvas to English. So I think I'll be able to present in English.
Oh, it was a challenge, yeah.
Yeah. So let's go. My work is when autonomy is necessary for performance. I study on Brazilian public defenders' offices. It was a part of my PhD thesis. It's a chapter on my PhD thesis that I did in Getúlio Vargas Foundation in São Paulo. A little bit about public defenders' offices. Let me share my screen. Well, these offices are agencies created by the state to provide legal aid to vulnerable citizens. And these agencies litigate directly against the state in cases where when public policies have flaws, specifically public policies that are aimed for citizens in situations of social or economic vulnerabilities. So these agencies act in specific group of people. For example, people who live in the streets, people who are working under slavery, migrants, and so on. So it's a very important type of agency. So this agency is mostly endemic here in Latin America. There are a few exceptions, but here in Latin America, the design of this policy for legal aid is public defenders' offices, these agencies that are maintained by the state to provide legal aid for these vulnerable people. As the public defenders' offices, I will say here PDOs, if it's okay for everybody. As the PDOs litigate directly against the state, it's very important that these agencies have autonomy vis-a-vis the state, so they can do their work and do the mission the way it has to be done. However, it's important as well that to establish accountability mechanisms to control, to have a little bit of control, at least on these agencies, because the bureaucracy, if the bureaucracy has no control on itself, it's possible that a bureaucratic drift is possible. So the bureaucracy starts to look to their interests instead of the interests of the population. So my research problem was, does greater autonomy perceived by the PDO's bureaucrats lead to higher levels of performance? And the research goal was just to test the impact of autonomy on the performance of Brazilian PDOs. So the theory on autonomy of public agencies brings it's a little fuzzy, and it brings three possible relationships on autonomy and performance. There are those works. There are works that
Show.
Talk about direct relationships. So whenever the autonomy, the levels of autonomies are high, the levels of performance are also high. There are other studies that talk about inverse relationship. So when the levels of autonomy are high, the levels of performance are low. And there are other studies that talk about curvilinear relationship, a little bit like this. So it's not the ideal world will not be high levels of autonomy or low levels of autonomy, but an equilibrium between these two extreme points. Well, having that in mind, I just launched the 7 hypotheses. Hypothesis 1, high levels of autonomy lead to high levels of performance. 2, greater resource availability leads to higher levels of performance. The relationship between autonomy and performance is mediated by the availability of resources. Hypothesis 4, the skills levels of bureaucrats are positively related to performance. The skills of PDOs bureaucrats moderate the relationship between autonomy and performance, and higher levels of autonomy leads to high levels of accountability. High levels of accountability leads to high levels of performance. And 7, the level of accountability moderates the relationship between autonomy and performance. Well, this figure here is just to show the hypothesis and the theoretical model. We have here 5 variables. These main variables, skills, accountability, performance, and resources are these variables that lead to skills, accountability, autonomy, and resources are variables that lead to performance. So this is a figure that shows the hypothesis. And to collect the data, we applied a questionnaire to public servants and public defenders of public defenders offices in the states of the Brazilian states, the federal district, and the federal PDO. There was 325 responses from 27 PDOs. In Brazil, we have 28. Only the Pernambuco state PDO was left out. And the questionnaire was, this survey was adapted from instrument on state capacities developed by the Instituto de Pesquisa Econômica Aplicada, which is a public agency here in Brazil, and the Center of Democracy, Development and Rule of Law from Stanford University. Well, for the analysis, I performed structural recursion modeling and used for that RStudio and Honest. And well, this methodology allows us to estimate the relationship between variables that are observed and variables that are latent. If you see here, these variables that are in circles are latent variables, and these variables that are in squares are observed latent. These are the items of the questionnaire. Well, these are the main results. Here I put just the main regressions, so you can see that almost in all of the models, autonomy is positively related to performance. I've done here another figure just to show it more clearly. So autonomy is positively related to performance. If you see here, this relation. It's also positively related to resources, and resources are negatively related to performance. This is this result might be because of the feeling of the bureaucratic that they always need more resources, and it's like a constant in every public service agency. Skills are positively related to performance, and accountability is also positively related to performance. Skills does not moderate the relationship between autonomy and performance, and accountability moderate this relationship. So let me clear these drawings. Well, for the concluding remarks, this study established the foundation for the study of autonomy of PDOs. It also indicates that accountability has greater influence on performance than autonomy, and it shows that some aspects of autonomy are necessary for the performance of PDOs. There are also some practical contributions as the demonstration that autonomy is important for the performance of PDOs, but this autonomy cannot be confused with independence, as some accountability is also necessary for the performance. And there is an indication that accountability mechanisms and the development of bureaucratic skills are also important factors for the performance of PDOs. So thank you very much for listening for my presentation, and I hope to get your feedback. Thank you once again, Caio, and the floor is yours again.
Thank you, Bernardo. We now will have the fourth presentation. Yeah. So the questions will be done at the end. I already have a question for Bernardo, but I will wait for the end of the works, and we will have the fourth work here. That it's the really the international work being presented here. We have not in this fourth work, we will have not Brazilian people conducting the work. We will have not Brazilian people being in the stage. We'll have Spanish colleagues here to present the work. We welcome our colleagues from Academy in Spain, and welcome you to be here with us debating issues related to administration of justice. This issue here about sexual violence involving women is not a typical performance issue as the other three were, but as it is in English as the other works, it was put together with us in this section. So the work that will be presented now, it will be Theory and Practice, Women Victims of Sexual Violence in Criminal Justice Systems, from researchers of Universidade Autônoma de Madrid. So I would like to welcome authors of this work to present it now. And the word is to Monique, yes, or Sabela?
Thanks, Caio. We are going to share.
To share,
are going
okay,
to
no
yeah.
problem, no problem.
And Monique is going to manage the presentation. I think so.
Yeah.
Okay, thank you. So good afternoon. First of all, I would like to thank ENAHU's organizers for letting us share with you some of the results of the Treaty European project. We are going to split our presentation into sections according to our institution and research in this project. Autonomous University will present an approach to criminal justice and sexual crimes, and the University of Leuven, the best practice and standards. So I will move to the topic. The Victims' Rights Directive of 2012 envisages an individual assessment for every victim. And we must not forget that the law expressly mentions sexual violence. The transnational report has been made from the information of the previous national report of this project. So with this approach, we try to go beyond the national borders and provide a wider picture on the drawbacks faced by these victims. As everybody knows here, it's not easy to do a transnational report that want to focus more in empirical data than in theoretical one. So because adding some empirical data, like for example here on criminal justice, is more difficult in some countries than in others. All in all, we are quite happy because it gives a panoramic picture on the evolution of sexual crimes in these countries, as well as the challenges faced by these victims before, during, and after criminal proceedings. To be realistic, I cannot cover every issue, so I'm just going to focus on some of them to stick to the time of this panel. From a substantive criminal point of view, the three systems had experienced a general similar evolution. There has been a paradigm shift from the protection of the prevailing sexual morality in our societies to a current effective protection of our individual sexual freedom. However, this radical change came in a different time, by far in Italy and in Spain before than in Greece. There is a divergence on the concept of a sexual violence as a gender-based violence, because here in Spain, we have a narrow concept of a gender violence, limited only to the one that takes place in a family domestic context and not outside that space. Sexual consent plays a central role in all three systems. However, there are some differences on the age from which a person is entitled to give a valid consent to a sexual relation. A comparison of the scale of penalty, it will be very complex, but it seems very clear that there has been an increase in the severity of these offenses. There is a considerable disparity on aggravating and mitigating circumstances, and sometimes the same circumstances, like for example, the chemical manipulation, plays the opposite effect in one country and in another. Generally speaking, the three systems configure sexual offenses as a sort of an intermediate category between public and private crimes. The biggest differences lies in the effectiveness of a victim intervention after the start of the procedure. In Italy, the victim report is irrevocable, while in Greece, the victim can decide if she does want to go ahead with the prosecution. When we move to procedural and organizational matters of our criminal justice systems and following the structure of the directive, I will only say something about some of the rights. Let's start with the right to understand and to be understood. The directive established that the authority must give information to the victims in order that she can exercise her rights. Pay special attention to the personal characteristics to ensure an adequate communication and provide information effectively to ensure that the victims understand it. Despite the growing interest of all professionals to make information on the dynamic of the criminal proceeding more accessible, this is an aspect that needs to be improved. Victims consistently express confusion, a lack of understanding, and a great uncertainty during criminal proceedings. So we need to improve the communication techniques during the process. We need also a specialization training on victims' interest, and we have to get rid of bias associated with these crimes that of course also have professionals. Another point of concern is the support. There are victim support services with a greater or lesser degree of specialization in sexual violence. However, they are very far from meeting all the needs of a sexual victim. Furthermore, there are significant differences in terms of access and the multidisciplinary nature of the support between rural and urban areas. And it is important also to grant this support even after criminal proceeding, as well as in the cases of non-reported cases or prescribed offenses. Unfortunately, there is a great discrepancy in the way in which professionals claim to act and the perception of the victims. This provokes a great insecurity in the victims, very tough at all stages, but especially terrible in the initial ones. Sometimes the situation improves if she receives legal aid. But when we move to the right on the right to legal aid, national reports present a significant variation. While Italy guarantees this right, this is not always the case in Spain, while the victim has to meet certain requirements to access to this right. Related to the right to be heard and focusing only on the investigation phase, there is a clear discrepancy between the perspective of the police, prosecutor, and even investigative judges and the perception of the victims. On one hand, police thinks, or they know that the relevance of having an active listening. They think their questions are only focused on the description of the events, and they try hard to avoid suggestive questions. The opinion of the investigative judge, as well as the prosecutors, is quite similar about their interaction with the victims. Unfortunately, victims' opinion is quite diverse. They file questions. They suffered a large number of direct and specific questions which prevent them from expressing themselves in their own words, and they do not feel heard. A deeper look into the practice shows a different panorama in the effective guarantee of the right to report to a person of the same sex. Because in Greece and Italy, the victim has not the right to choose a police officer of the same gender. About this question, professionals, operators, and victims agree that the appropriate treatment of the victims depends on the skill of the reception, on the active listening, empathy, and support. And these characteristics do not depend on the gender, but on his or her training and specialization. So we can say, as a conclusion of this first part, that there is a unanimity among professionals and victims regarding the need for a greater and a better specialization among professionals of criminal justice in treating sexual victims. Thank you. Now it's the time for Monique.
Thank you. I hope you can see the right screen and that you don't have the notes. So Bella, is it correctly
Yes,
displaying?
it's okay. Yeah.
Okay, perfect. Thank you. Hi, it's lovely to be able to present our research to you this day. My name is Monique. I'm actually based in Leuven in Belgium, so we are very international, this group. So I will present to you the part of the project that I've worked on. I'll first present a best practices framework, which can be used to evaluate and to look at the work that organisations do to support women with who have experienced sexual and gender-based violence. And then I'll present to you the practice standards guidance, which we've put together. I will use the word victim following from the European Commission 2012 Victims Directive, but I'll just want to acknowledge that I appreciate that many people who experience sexual and gender-based violence prefer the term survivor. Okay, my colleague and I, we have proposed an evaluation framework which can be used for understanding effective practices when working with women victims of sexual and gender-based violence, as I've mentioned. This has 3 thematic pillars. As you can see, they are knowledge orientation, practice orientation, and system orientation. And in each of these 3 pillars, there are subtopics. And we call these the key elements of effective practice. So these 9 subgroups that you see are the key elements that indicate good practice within such an organisation. This slide is just to demonstrate that there is a link and a synergy between the elements of the framework and the 2012 European Commission Victims Directive, particularly with the second pillar. In our research, we did lots of desk research, but we also very much look towards practice. We're very aware that sometimes practice is far ahead of what is actually officially appears in journals. And we've presented many examples of how, concrete examples of how the good practices can be implemented in practice. So this is just an example of a project which happens to be in the UK. This organisation works with women who are sex workers. They provide practical support to these women. For example, a woman can provide a telephone number, and the organisation can say if the number is associated with somebody who is likely to be dangerous or is already known to be dangerous. If the woman wants to report to the police, they'll support her to do so. If she doesn't want to report to the police, then the organisation in any case makes a report of a record of the violent incident. So this is really important because otherwise these incidents are not captured anywhere and women are not able to be kept safe. So we see how this organisation is a very good example of how to respect the privacy of the women, to allow them to be heard and understood, to provide them with validation and vindication, but also to ensure that they have their agency and they are empowered and they can stay independent. So in our report, we also present examples of where we can learn from practice, so where things perhaps didn't go as well as they may have done. This example is the Sapphire project in England and Wales, where police officers were specifically trained to work with sexual violence victims. However, it was found that the pressure on the police, they were given pressure to resolve the cases, which then caused the officers to discourage the women from reporting sexual violence if it was unlikely that the case would be solved. So we see here how giving training to professionals isn't enough. The wider professional context is also very important, and there's also a lot that needs to be done in the context of these professionals to enable them to provide support to women. So from the framework that I've just introduced you to, we had these key elements of effective practice, and based on those, I put together some practice standards. There were 9 practice standards developed. It's a guidance for justice professionals, which the idea is that it's simple and easy to use, and it's aimed at strengthening justice processes and achieving better justice outcomes. We were assisted in this task with feedback from justice professionals in Spain and Greece and Italy, who helped us to come together and to put these practice standards together. And there are synergies between our work and existing documents that judicial professionals will be familiar with, such as, for example, the 2002 Bangalore Principles of Judicial Conduct. It's non-binding guidance, but by subscribing to it, the practice standards, judicial professionals, they can demonstrate their commitment to more effective ways of working. And I'll just introduce you very briefly to some of the practice standards. So they're associated with the three pillars from before. So for example, linked to the knowledge orientation. And in the actual document, of course, we give much more elaborate information, and we also explain why the points are important, drawing from the research, and we give examples of how judicial professionals can implement these practice standards in their daily work. So as you see this on the knowledge orientation, professionals will seek to understand the phenomenon and different types and characteristics of sexual violence, and indeed the context in which it takes place. So why is this important? So it's important for professionals to understand the broad range and types of sexual victimization. And that includes them not underestimating, for example, the impact of non-contact harms. So the impact of, for example, online sexual abuse. And also that professionals will recognize less familiar harms, such as, for example, a man removing a condom during sexual intercourse without the permission of the woman. Professionals should be aware of the high likelihood of shame and guilt within this type of harm, and understand how these emotions contribute to, for example, women not wanting to report the crime because of a social taboo, or their fear of being blamed, or also their fear of not being believed. And it's also important to understand the context. So, for example, something quite familiar to us all now is how COVID-19 and the lockdowns have impacted on the experience of sexual violence. People have had to stay home, they haven't been able to access services, and all of this has increased sexual violence. The second lot of practice standards are around practice orientation. And in this cluster, it focuses on, we see how important it is for professionals to understand how to make services available for victims and also accessible to them, and also to understand how the barriers to access can be reduced. These barriers can be due to individual, interpersonal, organizational, or socio-cultural characteristics. So for example, by participating in the criminal justice system, participation in the criminal justice system is influenced by victims receiving and understanding information. And this might perhaps seem very simple on the surface and a very basic right, but actually in practice, we see that it is often quite poorly executed. And finally, we have practice standards related to system orientation. And this relates to how services operate, the quality and evaluation of practices, including the ethos of organizations, and how different services can cooperate in a victim-centered way, and including the importance of improving the skill of practitioners. So the practice standards are something that professionals can commit to as individuals, but ideally, as I've mentioned, context, organizational culture is very important. So ideally, these would sit within a wider policy framework, and within the project, we're currently working on some policy recommendations as the next step. So that was very quick. I hope it wasn't too quick. Thank you very much for your attention, and we look forward to receiving questions later on.
Thank you very much. Thank you, both of you, for the presentation. Now I have some questions for everybody. Starting about the first one, the first work, that this is this fight between transparency and data protection, explaining for everybody perhaps one thing that triggered this debate in Brazil is that we recently approved a data protection law in Brazil, and many people, many business, many presentations are being done about data protection. But I think that we have see data protection with different eyes when we talk about private data managed by private business and data managed by public organizations. Because sometimes public organizations need personal data to achieve a better performance, including offer a better public service. So the data protection law, they treat different public organizations and private organizations. But I have a question for the authors of the first, to Luisa, the author of the first work presented here, is that if in Minas Gerais, in the Minas Gerais State Court where the project was conducted, I entered in the internet here to see the CJUD during your presentation. I see that there is data, there is a personal data presented, and this is very good in my opinion, because transparency is the highest principle here, that the most important principle that we should pay attention. But my question is, some judge or some judicial assistant have made any complaint because this data is shown in internet? Have you heard something about that, or there is no complaint about this initiative, this transparency initiative? Remember that we have the Brazilian National Council of Justice put in the internet the performance indicators of judges and assistants of the entire country. I understand that the CJUD brings a new layer and more information about their performance. So my question is, have you heard any complaint of people that are being exposed? But I know that it's not an explosion, it's just a question of transparency, but you have this you may have these internal complaints. Have you heard about that?
Okay, thank you for the question, Caio. We haven't heard of that. If there is, we haven't heard it. Was not in our researches. As I showed in the presentation, the thing that was more related to that was some complaints about the publicity of the salary of the public servants, but related to performance and activities, no. And the salary is really established in the courts of Brazil nowadays, that it is a good practice of transparency. And in the secretary, that is the VARA that we worked on with this project, actually the judge asked us to create another platform more related to the judge work itself, because here we were talking about a little bit different. It's not the judge and the work that they do, but she actually asked us to create another one. So we don't know about some complaints, don't have complaints about it yet.
So this is the perfect situation, because you have no complaints yet, and the judge where you work is trying to increase publicity, increase transparency. You are working really in a good atmosphere for transparency. Yeah, of course. Okay, thank you, Luisa. My next question goes to Bernardo. Bernardo, perhaps one of the most intriguing lack of relation presented by you is the lack of relation between resources and performance. Because usually when you talk about autonomy, everybody thinks about autonomy related to resource, but budget autonomy to expand, to make expenses where the organization think that it's more convenient, and perhaps when you have more resource autonomy, we can have a better performance. And your report, your work work show a lack of performance between resource and performance, a lack of relation between resource and performance. This is a very intriguing result, if I understand correctly. And I would like some more words about this lack of relation.
Yeah, it's really intriguing. I believe that it's because my research was I was looking at perception of public defenders and public servants, and they usually think that they lack resources. If we compare with objective data, these public defenders offices in Brazil have multiplied the resources that are at their disposal. So I believe that, and I have to bring it to the paper, that this is because of the perception of the workers, and they always feel that their wages must be better, and they must have more, and the environment that they work must be bigger, and so on. So I believe that this is the point.
Yeah, when we have data achieved through perception questions, perceptional research, we can have this kind of bias. Yeah, this is very natural. Another question. In Brazil, we have this prosecution offices on one side, and we have the public defender offices in other side. Both have constitutional autonomy, but I heard that the autonomy is not the same. So the public defender offices has not yet this exactly the same autonomy of the prosecution's officers have. Is that right, or they have the same autonomy?
It's very similar. It's really similar. The public defender's office were built looking after the prosecution officers. So they envy the prosecution offices, and they try to mimetize the institutional arrangements. But I will say that public defenders offices in Brazil have more autonomy than the prosecution offices. For example, for the election of the election or the nomination of the general public defender, the public defenders vote and elect a list of 3, and the president of the republic picks one. It's a law for the public defender's office. For the public prosecution office, the general prosecutor, it's the same. It's the same process, but it's common sense. It's not written in a law. So in the public defender's offices, it's institutionalized this type of autonomy to choose the general public defender. So I believe that the autonomy of public defender's office are similar to public prosecution, but are a little higher than their autonomy.
It's exactly the opposite, yeah. Because we have the I didn't have heard this characteristic that this list of 3 was written in law. This is really something new for me. Thank you, Bernardo. In the 4th work, we heard initiatives and research about reports involving sexual crimes. Yeah, we have 2 authors mentioning that. My sister in Brazil is a psychologist, and she is also now a university professor, but during her master degree, she helped public offices. She trained public officers to have a different and more sensible approach to victims of sexual violence. And she explained to me how different is the approach in this kind of crime compared to other kind of crimes. And I saw that some questions, as you explained, usually traditionally they ask questions related to verification of the facts, and this is not something that victims feel comfortable. I imagine. And my question is, do you see in Spain or in Belgium that the work is this work of training offices of creating specialists offices that are specialized in this kind of work is increasing, is developing, or no, or we are yet in the debate about asking for this kind of thing, or no, or the policies are really developing in this way. Here, for example, in Brazil, for some years from now, we have created specialized police offices for women. So if a woman go to report, for example, something, she does not go to a general police office. She goes to a police office that is specialized in women crimes or misdemeanors. So what's the situation in Spain and in Belgium? Policies are improving or not? Monique or Sabella?
Well, I think of course the situation is not we have improved if we compare with I don't know 30 years ago or so. And of course all professionals have improved their awareness about how to care or how to treat sexual victims. However, sometimes they do not receive, it's quite difficult. They do not receive a training, or perhaps the training is not sufficient, because this is something like you have to you have to think about your work, because they when we interview them, they always say that, okay, I know the theory, but in practice, then I do not have time, because courses are overloaded, as you say, Caio. So it's like here at the university sometimes, but it's not the question, because I have a lot of classes, for example, at the university, but I have to treat with dignity my students, even if sometimes the questions, as you said, the description of the facts is quite difficult, but you can do it well or bad, and even them they see in their own sector, like prosecutors or judges, that sometimes some colleagues do not do very, very well. For example, we found a sentence that of 2019 that a court, or the president of a court, asked the victim about her clothes. So this is like the, I don't know, something incredible, no? In this currently, but it happens. And we are planning some training in the 3 countries, so we are going to see. But I don't know.
Yeah, I think if I can just add, and I agree with everything Sabella said, of course, it's very complicated and it's very multi-layered. And I think it refers back to that knowledge orientation aspect, because we have this very important element of culture and context. And it's a sort of pervasive attitude around sexual violence and attitudes towards women. And no, that you can only go so far with training to kind of try and deconstruct what is essentially kind of issues and ways of thinking that are perhaps very embedded in culture and very embedded in society. So when you have, as Sabella mentions, this reflex to blame the victim for what she's wearing, or to question, well, was she drunk? That's very embedded, and there's something quite structural then that we also have to address. So on the one hand, of course, you can give training and you can give information, so this knowledge orientation. Part of that is to help people to recognize that we all of us as human beings have biases, and that's just how the human brain is wired. It's a cognitive shortcut. So part of it is to kind of train that and to give the knowledge and the information, to give the reflex to think and question oneself and one's practice continually. It's reflective practice within work. But also there is this kind of more structural level that we have to tackle. So we are seeing improvements, and there is training, and you know, of course there's always more to be done, and we have seen improvements, but that there is a wider question, and I think there's a bigger picture here as well that's very important.
Okay, so we are improving. Some people, some officers have the theory, some officers have the practice, but of course this structural point will take time to be addressed. Yeah, but of course this kind of debate, this kind of research is essential for tackling this level. I expect that in some years we can have some kind of better situation for the women that are victims of sexual violence. Thank you for the debate. And Monique has made very politely, very gently, a question for me. Yeah, so I will report the question here, Monique. Caio, thank you for your very interesting presentation. You highlight the clear benefits with respect to efficiency, but do you see any risk of such a system? Yes, there is a risk. Of course, when you create costs for access to justice, some specific people that are not able to pay for their costs, they may have this access hurt, but I don't think that it's usually the case here in Brazil, because the main costs that it was created now is the cost when you lose the case or when you exaggerate your claims. And then you will have to pay to the other side. Usually, when a legitimate employee file a case, he will not have to pay anything after the reform. Okay. Of course, there is a risk. Sometimes a legitimate employee loses the case, and he needs to pay something and he has no resources to that. But this is the risk of the judicial system that is intrinsic and inherent of the system all around the world. Yeah, the judicial decisions are not perfect and every time, and I think that the cost is too much to address this kind of system. The cost in the budgetary cost that could be redirected to directed policies, public policies like sexual violence, for example, or education or health, and give free access and no cost for everybody, for every employee is not rational in my view, as it's not free in most of other countries and most of other litigation in Brazil. So yes, there is a risk, but I think that's a risk that does not compensate, and it's not so high.
Thank you.
Yeah. So Any more questions? And anyone would like to make another question or another point in our discussion here today? No? So if not, I would like one more time to welcome everybody to see other presentations today. And in the next 2 days, we'll have this long administration of justice meeting. And this is the first year that it's made in 2 countries, Brazil and Portugal. And I'm certain that it will be very interesting to hear other researchers presenting their works. Thank you very much, everybody. I see you next time. So